to come before the court this morning is In Re DJ. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you are going to reserve any time for rebuttal, if you let me know when you get started, I'm keeping track of the clock. You can also utilize the reference to the clock that's on the wall over there, which is the same clock. The arguments are being recorded, so please stay behind the podium, keep your voice up, and don't use the names of any victims of crime, minors. I don't think that's necessarily relevant to this case, but that would also include any deceased minors or victims of crime. The judges have read your briefs. We're ready to proceed when you are.
Good afternoon, judges. My name is Stephanie Kessler. I represent the appellant, DJ. I would like to reserve 3 minutes for rebuttal. And in this case, I do think the juvenile court abused its discretion in not proceeding with the evidentiary hearing in this case. With respect to the issue of cross-examination of the state psychologist, the trial court did grant discovery. I think what is not before this court, unless it was addressed at the last appellate argument, is the fact that depositions were taken of Scott Spum and Jennifer Albert. In those depositions, Jennifer Albert was asked, is the JSO the main instrument that you use to direct sex offender treatment? She said yes. So now when we look at the trial court's decision, and she's saying, well, I didn't use the JSO test results because my decision was based on her perceived issues with his treatment. Well, that doesn't fully resolve the issue because the treatment is derivative from this test. And I think that should be flushed out at an evidentiary hearing.
So if I understand you right, what you're saying is that because, I don't remember her name, but the therapist, whoever who testified in deposition said that was her primary methodology in order to determining like his recidivism or his treatment, whatever. That the trial court could say, well, I didn't consider the results, but in essence, the trial court did consider the results through the back door because that all planned the treatment. So.
That's exactly my position. I think to further it, when Scott Spum was deposed, he was asked, or he actually testified that the JSU was used to determine whether or not a youth is appropriate for high treatment or lower treatment, and whether or not the treatment needs have changed. And I think that issue dovetails into the need for an expert. I think one of the biggest points here in this case was raised on the direct appeal following the SYO, and that is the data shows us that unlike adults, only 8% of youth who recidivate, or only 8% of youth will recidivate with future sexual offenses. So the default here for youth is that they're not going to re-engage. They are not going to re-offend. We don't have that substantial danger to the community. And I think what the record is lacking that would have been fulfilled by an expert is there data that supports a relationship between treatment and recidivism? It's great that the state of Ohio provides this treatment. I think it's wonderful. I think it should certainly be done. I think it's definitely steps in the right direction, but that doesn't mean that we have, by clear and convincing evidence, that failure to engage with the treatment, even if it is appropriate for his age, necessarily tells us that he's likely to re-engage in future sex offenses. And while I'm on the topic of the expert, I do want to touch base on the lack of an affidavit. I do see that's been raised in the briefing. I think timing on that issue is really, really important here because that post-conviction petition was filed on January 29, 2018. Shortly after that, on February 28th, a hearing was granted, and that hearing was granted before the state responded with the motion to dismiss. And the reason I think that is important is under the post-conviction statute, the 2953.21 subsection G, a petitioner can amend without approval of the trial court the post-conviction petition and provide additional information. Now, I think an appellant can also do that after the state has responded, but then only with the court's permission.
Counselor,
Counselor, is there a jurisdictional issue here? The DJ is now an adult, and the statute says the juvenile court has jurisdiction over a person who is adjudicated a delinquent child or juvenile traffic offender prior to attaining 18 years of age until the person attains 21. And there was an adult sentence imposed prior to 21, but now we're talking about post-conviction remedies in this case.
I think that's an interesting point. I don't have the case law at my fingertips, and would be happy to provide supplemental briefing if this court requests it, but I do know that I've come across that in similar issues where when a court of appeals decides that the rightful legal option here is to remand the case, but the court has lost jurisdiction, then that does become an issue, and I do think that it's possible here, although again, I don't have the case law in front of me, that this hearing couldn't happen, but that's where I think the trial court erred in deciding these issues. She's decided that the evidence she has not heard will not change her position, and I'm not sure that that's the appropriate choice here. I think some other arguments could have been made with respect to the Fifth and Sixth Amendment issues that were raised, and I want to address what I think the benefit of counsel would have been to a youth and DJ situation here, and it's not that we can sit in through the actual exams, we can't, and it's not, as maybe has been suggested, that we coach or teach a child to say what's best to get the results they want. It's really to address misunderstandings. I think it is very reasonable for DJ in this case. He knows the facts here are egregious. These are egregious facts. There's just simply no other way to cast them.
Let me just stop you there. Does he know the egregious facts? Because one of the things that the state's argued is he has no empathy, no understanding whatsoever as to how egregious it was, and that he literally raped and killed his sister.
I'd like to address that in 2 points. I think one, that's a conclusion and may be a reasonable one, but not the only reasonable one. What I would expect for youth and DJ situation here is to be concerned that if he is honest and he is direct and he really dives into what happened and why it happened, he is scared that the adults in this situation will do exactly what happened here and invoke the SYO. As a defense attorney, that's exactly what we would gauge with youth at this stage, is say, look, we understand that fear that you may have, but actually what you need to do here is be 100% open and honest. You cannot hold back, you cannot worry what somebody might think. You have to engage in this treatment, which means you have to be transparent and honest. And that's the benefit defense counsel would have provided. I think in terms of whether or not he shows remorse and an understanding, that issue touches on how the JSOAP has permeated, at least based on the record that we have, this entire case. So an expert could have stated, well, the JSOAP isn't appropriate for him because these are some other different ways that we measure treatment success for this type of youth. It could be that if pressed on cross-examination, I don't know if DYS has other methods of measuring treatment or deciding what they do. I don't know what they did before the JSOAP too. And some of those answers might get us to what should have been done, were there other options, and to be perfectly candid, that evidence could be bad for the defense, right? Because we're dealing with an unknown.
Well, I guess I'm confused because the items I was mentioning, I thought were basically determined by the letter that he wrote. So that would have nothing to do with test the victim letter.
I'm not sure how the need for that letter fits into the actual test and whether it's part of it or different, but even so, I think it's an odd issue for me. For me personally, I can understand how you would decide not to write it to a 3-year-old and to write it to the parent. I think that that's a reasonable choice. Now, I do see that it has been pointed out that even so, the contents of it aren't exactly what we would hope to see. But again, I think that that would be something that could be addressed if he was afforded counsel prior to this JSOAP, which may have invented the letter or may have involved the letter, to make him understand the circumstances here and that withholding, thinking it's in his benefit to withhold, is actually not the right way to go. I mean, most of my practice is in the Southern District of Ohio Federal Court. We have something similar called a proffer, where you sit down with the prosecutor and your client is tasked with being 100% honest about every question asked. You cannot decide not to answer, you cannot hold back, you cannot meander around, and we have to have multiple counseling sessions with those clients, because no matter how much you tell them that, you have to sit there and really work with them to get them past the fear of repercussions to that state where they are honest and open. And I don't think that that happened here, and it could have been because he was not given counsel. But I do think the facts about what that may have done and how the letter fits into all of this would be better suited to an evidentiary hearing where those facts could have been elicited.
I think I understand your argument, but I'm trying still to figure out why would that have anything to do with counsel? A counsel shouldn't have to advise somebody that's been being treated for 6 years that he should be empathetic and remorseful for the actions he took.
I think a person can be empathetic and remorseful and not act on it, not say it out loud.
Well, he was essentially resentenced.
I
In
think
a
it's right.
normal circumstance, you'd have counsel for sentencing.
Mhm.
Is that what you're trying to say? That he needs to have counsel to advise him of how he should behave to affect his sentence? It's a hybrid sentence. You had a whole new sentencing entry because he had a juvenile sentence and then he had an adult sentence, and there was obviously proceedings between that. Is that what you're trying to say?
I think so. I would say it's a little bit more explaining the process to him and addressing any misunderstandings he has than necessarily tell him how to behave. And I think, for example, my husband is completely allergic to saying I'm sorry. It's just words that are not coming out of his mouth for any reason whatsoever. But he then shows conduct that show that remorse. He'll change whatever the issue was. He might behave differently. And so I think we could potentially run into that circumstance here where the youth in question actually is remorseful. He does understand it, but he's not showing it. And we don't know right now, based on this record, if his not showing it is because he had a misunderstanding that nobody was there to correct for him through advice of counsel, or if, it could just be that he didn't like the people that he was interacting with, right? As adults, we know that that doesn't matter. It doesn't matter if you like the person, you have to engage in this process, you have to transparently involve yourself in it, whereas this youth knows that if he gets out, there was a treatment plan in place. So it's possible too that he thought, well, I don't have a good relationship with this person, I'm gonna seek treatment once I get released, I'll really engage here. And again, we don't know that because the record isn't here, because defense counsel didn't push on the JSOAP enough, didn't push on how did that drive a treatment decision. Is this letter part of the treatment decision? We also don't have really a lot to go on in terms of how this letter fit in and whether or not, do they always do letters for the 8% that recidivate? Do those 8% write these letters? Is that at all indicative of whether or not we're going to have future issues with this particular youth or not?
And counsel, you're just now reaching that 3 minutes.
Then I will rest.
Good morning, Your Honors. Counsel, may it please the court, I'm Jacqueline Corrigan on behalf of the state of Ohio to quite obviously ask you to affirm the decision of the juvenile court in this matter, because of the 4 reasons why DJ believes that his trial counsel was ineffective, he was unable to meet his burden in a post-conviction relief petition regarding any of them, and therefore the juvenile court in this matter did not abuse its discretion when it denied DJ a hearing and denied post-conviction relief. And that's for a few reasons. First of all, regarding post-conviction relief, the court must keep in mind that in Ohio, according to the statutes that govern post-conviction relief petitions, post-conviction relief, even a hearing on a post-conviction relief petition, is not granted based upon speculation about what you don't know. It's granted based on evidence that you present to the court about what you do know, about the constitutional violations that you believe occurred in your case. And that's the entirety of the basis for this post-conviction relief petition in this case. And referring to the depositions that were taken, I would remind the court that they were not filed in the juvenile court. They were not before the juvenile court before this case came up for oral argument and decision the first time, or even this after the juvenile court disposed of the arguments in the second time, which is why we're here today. So none of that was before the juvenile court at any stage. There also was no expert opinion that was proffered at any stage, even though there was supplementation of the post-conviction relief petition at the juvenile court prior to it coming up before this court on the first occasion. The only supplementation was not with the opinion of an expert, but was merely the affidavit of the Mr. DJ. Getting to the ineffective assistance though, that evidence had to have gone to proving ineffective assistance, which has two components. Not merely the objectively deficient performance of counsel, without which, as the second component, is without which there would be a reasonable, not speculative, but a reasonable probability that the juvenile court would have released DJ upon his 21st birthday rather than sending him for the adult portion of his sentence. DJ's burden in this case was to show both, and he showed neither. Now, there was no objectively deficient performance by counsel regarding, and by objectively deficient performance, I have to remind the court that that doesn't mean second guessing on the part of the second attorney or even dissatisfaction on the part of the client. It has to be a blatant violation of the standards that we all operate under, of the care, and it's basically akin to malpractice. Now, concerning the individual points that DJ raised in the petition, was that, first of all, that his counsel inadequately cross-examined the state's witnesses concerning the JSOAP2 evaluation. The mere framing of that, inadequately cross-examined, indicates that it is the result of second guessing rather than objectively deficient performance. Because trial lawyers have significant latitude in crafting their trial strategies. And there is no requirement that an attorney must proffer or must follow futile strategies. Now, additional cross-examination concerning the JSOAP2 would have been futile in this case. Factually, because it was administered to DJ when he was still 18 to get an initial baseline to find out what kind of treatment he needed, but then it was not relied upon by the testimony, or by the professionals, Dr. Alpert and Mr. Spahn, when they testified to the juvenile court when the adult sentence was being invoked by the state of Ohio. They relied instead on his statements that he made to them in treatment over and over and over and over again. So he had chance after chance after chance to be open, to be honest, to be transparent. Instead, every time these professionals testified that they asked him, why did this occur? He did not know. That was his repeated statement, I do not know. He never, ever fully engaged with his own feelings or indicated to, in any way, even while he was vacillating as to whether he would take responsibility for his sister's death or not. He never satisfied what the court needed to know, and that was, did he have any clue why he did this to this girl so that he could not do it again? Then, again, there was no expert that was proposed at any stage of this litigation concerning the JSOAP2. There was no affidavit, and so that burden was unmet as a factual matter. Then regarding the suppression of statements, the state would submit that the case law regarding this area does not support that a person going in for sex offender treatment, once their appeals have been exhausted, as DJ's had been at the time when he finally started sex offender treatment, that there is no A, right to be Mirandized concerning those, or B, a right to counsel to essentially, what would still practically, they would have to sit in with him or be there for every treatment session to advise him how to be, as counsel says now, open, honest, and transparent. And I would remind the court that that was not how that was phrased, or not how that was presented to the juvenile court in this petition. DJ, in his affidavit, said he wanted to be told by counsel how to respond. So there is no real indication in the petition even what he wanted suppressed. So there is no objectively deficient performance in failing to raise a suppression motion regarding either of those points. Then there's also no prejudice, which I've been rather touching on in addition to my arguments concerning no deficient performance. In this case, the juvenile court said in its ruling that even if there had been more cross-examination concerning the JSO2, even if an expert had been proffered to the court in this post-conviction petition, she would not have made a different decision. Even if those statements had been suppressed, a suppression motion had been made, no different decision would be made. He would still be in adult prison, and the court said that explicitly. We have to rely on the long-standing proposition that courts speak through their entries. So rather than speculating about what must have gone into the court's decision, the court has told us what went into her decision. And the consideration of the JSO2 was not among them. But even if the court had not said that explicitly, regardless of whether that JSOP evaluation had been administered, the treating professional still, in the hearing to invoke the adult sentence, still testified from their experience with this individual and their experiences struggling to treat him, that it was based on that they opined that he was not rehabilitated, and in the 29 months that elapsed after the end of his appeals till the time that he came up for this hearing, that he was not rehabilitated in the Department of Youth Services, and in the time remaining could not be rehabilitated in the Department of Youth Services. And also, if, let's say for the sake of argument, that counsel had filed a suppression motion and it had been successful, the statements that would have been suppressed would have been all of the statements that this defendant made to the people who were attempting to treat him. In other words, nothing. There would have been no indication to the court, as the court noted, that we've had no evidence whatsoever to have based any kind of decision saying that he was rehabilitated, because it would have been a lack of answers. And also assuming that he had been Mirandized prior to every treatment session. Had he chosen not to answer questions, there would have been nothing to have indicated that he was successfully completing treatment. It would have been just as it was from the time that he went through and was initially found to have been delinquent until the time that his appeals were exhausted, where he was refusing to undergo treatment on the grounds that if his case were reversed, that he would not have to incriminate himself.
I assume these hybrid sentences are rare in juvenile court. Do you think there's a jurisdictional problem here?
That was an issue that neither of the parties had considered, and
But the court can consider jurisdiction.
this court can consider subject matter jurisdiction at any time. I think that because neither one of us had considered whether there was subject matter jurisdiction, I think that it is an issue that if this court would request further briefing, we should engage in. But And I would be willing to do that. So unfortunately, I cannot answer your question. I think it's going to take another deep dive into the case law to figure that one out. But regardless, on the merits itself, this defendant did not show to the juvenile court, under the standards that are imposed for post-conviction relief in Ohio by its statutes, that there was a factual basis or an evidentiary basis to even have an evidentiary hearing. It was all speculation and all supposition. So unless the court has further questions, the state would respectfully ask you to affirm and rest on its briefs.
Thank you, Counsel.
Thank you.
With respect to the state's argument regarding when would a defendant be given Miranda, when would he be entitled to Miranda rights or defense counsel, I do not think it's every time he's interviewed or every time he has treatment. I think it does come into play when the youth is reaching 21 and there's an SYO on the table, as I think most people should have anticipated in this case, given the facts. So I don't think it's that difficult to determine, okay, as this youth is approaching the 21st birthday, now it's time to start Mirandizing, now it's time to start involving defense counsel. And I want to be careful about what's required here to invoke the SYO. There is no sentence in the SYO invocation statute that says when a youth fails to complete treatment, you can invoke the SYO. That the decision or failure for whatever reason, or the perception that he's failed to engage in treatment to an adequate degree can only suffice here if that failure becomes a substantial risk to the community. And I don't see any data or evidence in this record that says those two things are correlated necessarily. I think, again, this is where an expert would have been great here. With respect, again, to whether or not prior counsel sufficiently introduced outside the record evidence, I would suggest a supplemental briefing on whether or not this can constitute invited error by the trial court. If a trial court indicates to defense counsel that an evidentiary hearing is going to be afforded, is defense counsel permitted to rely on that and choose not to supplement the record? That I don't know. That could be something, if this court's inclined to be interested, to do supplemental briefing on. And I do want to address the state's point that there's no evidence that the state's witnesses relied on the JSOB with respect to the treatment. Well, that's because they weren't asked. And I think the deposition tells us how that would have gone. As far as prejudice, I do think there is prejudice here. If the judge would have heard what the cross-examination of the witnesses looked like and found this topic that defense counsel suggested to be true, incredible, that could have changed, and likely would have changed her opinion. Further, it might have injured the credibility of those witnesses in her eyes. If that's bolstered by an expert witness who can also address any correlation that there may or may not be between the 8% that recidivate and how that may or may not even be related to treatment, that would be something that could ultimately change her mind as well. And as for the prejudice for the Miranda or the Sixth Amendment issue, if that letter doesn't come in, I do think we have a different outcome here. And I would agree with the state that because the issue wasn't addressed, be happy to do supplemental briefing on the jurisdiction as to whether or not the juvenile court even had jurisdiction once this case was remanded.
And counsel, regretfully, I need to inform you, you have utilized your 15 minutes allotted time for presentation today.
Thank you.
Thank you both for your presentations today. Court will take the matter under advisement. We will issue a written decision which will be sent to all parties to this appeal, as well as posted on the Ohio Supreme Court website.